High School, are you guys ready?
Yeah.
Excellent. Then, without further ado.
You may be seated. So welcome. We're first going to start off with each of our judges introducing ourselves. Then I'll have each of you introduce yourselves, and then we'll read the question. But before we even start with the introductions, I want to thank the teachers and the coaches, because you wouldn't be here without their help, and it's a huge accomplishment that you're even here. With that, I'll let Caleb introduce himself.
Thank you. I'm Caleb Monroe. I'm the Executive Director of Youth Celebrate Diversity, a nonprofit organization.
And again, good morning. I'm Terry Fox. I am a judge on the Colorado Court of Appeals.
My name is Allison Ide. I'm on the U.S. Court of Appeals for the 10th Circuit.
Okay, now into your question. Frederick,
Oh,
that's right. You introduce yourself, and then I'll do the question.
Hi, I'm Michael Walsh. I'm the senior.
I'm Sophia Reynolds. I'm a sophomore.
I'm Ty Harms. I'm a senior.
Okay. Now, Frederick Douglass wrote that the Civil War was not a mere strife for territory and dominion, but a contest of civilization against barbarism. To what extent did the Civil War amendments change America? What has been the impact of the Due Process Clause and the Equal Protection Clause of the 14th Amendment on American governance and society? What has been the impact of the Doctrine of Incorporation on American governance and society? You may begin.
When Frederick Douglass wrote that the Civil War was not a mere strife for territory and dominion, but a contest of civilization against barbarism, he referred to the struggle of all persons to achieve the same freedoms held by their so-called betters. The first evidence of this can be found in 1215, when the barons at Runnymede induced King John to announce in the Magna Carta that no man should be imprisoned except by lawful judgment of his peers and by the law of the land. The most important word in this statement is man. These guarantees of freedom were only extended to white Anglo-Saxon landowning males. This was also true in our own founding documents. This is evidenced as early as 1787 during the Philadelphia Convention with the adoption of the Three-Fifths Compromise, Article 1, Section 2, Clause 3 of the Constitution, and the Fugitive Slave Clause, Article 4, Section 2, Clause 3 of the Constitution.
Oppression intensified through various court cases that ruled that African Americans were not people, the most famous of which being Dred Scott v. Sanford in 1857. In his majority decision, Chief Justice Taney said Negroes had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. It is easy to see why the Civil War erupted and tore the states apart. After centuries of barbarism, civilization asserted itself in the bloodiest conflict in U.S. history.
The turning point came with the ratification of the Civil War amendments following the Civil War. The 13th Amendment expressly forbade slavery. The 14th declared that any person born in the United States is a citizen and that no state shall make any law that abridges the privileges or immunities of citizens. The 15th states that no person should be denied the right to vote on the grounds of race, color, or any previous condition of servitude.
Regardless of race, the 14th Amendment may be the most important guarantor of freedom. The Due Process Clause and the Equal Protection Clause of the 14th Amendment are the mechanisms that protect the rights of African Americans and other minority groups. The Due Process Clause states that the government must follow known and established procedures and not arbitrarily and unpredictably deny life, liberty, and property. This has been defined by the court as procedural due process, where the government must respect all of the person's rights, and substantive due process, requiring the content of laws to be fair and reasonable. In 1954, in Bowling v. Sharp, the court held that segregation in D.C. public schools was unconstitutional. In Lawrence v. Texas in 2003, the Supreme Court overruled a law in Texas that made it illegal for two persons of the same sex to engage in certain intimate sexual conduct. In both cases, the court stated that existing laws were a violation of citizens' liberty under the Due Process Clause.
The Equal Protection Clause states that no state may deny any person the equal protection of the laws. This clause was instrumental in breaking down the barriers that persisted following the Civil War. In the 1938 case, Missouri Ex Rel. Gaines v. Canada was one of the first where the court showed willingness to find discrimination due to segregation illegal. By not admitting a black man to the University of Missouri Law School, the university was violating the Equal Protection Clause. In 1948, in Shelley v. Kramer, Shelley was unable to purchase a house due to a covenant that prevented Negroes from purchasing land. The court held that such covenants cannot be enforced. The most famous application of the Equal Protection Clause is Brown v. Board of Education, where the court rejected the ruling in Plessy v. Ferguson and held that separate is inherently unequal in public schools.
In many ways, the precedent set by the Supreme Court and legislation adopted by Congress was ineffective in impacting the lives of those it hoped to serve until the Doctrine of Incorporation. The doctrine guaranteed that states would provide the same freedoms provided by the federal government. In Gitlow v. New York in 1925, the court held that states were bound to protect freedom of speech. The precedent set in NAACP v. Alabama in 1958 is one of the most important rights incorporated, the right to freedom of association. The court stated that freedom of association is vital to freedom of speech because many individuals do not speak freely or effectively until joined with others.
The Equal Protection Clause, the Due Process Clause, and the Doctrine of Incorporation have done more than just protect the rights of African Americans. In 1965 in Griswold v. Connecticut, and in 1973 in Roe v. Wade, the court created the right to privacy. In 2015 in Obergefell v. Hodges, the Supreme Court held that gay marriage was unconstitutional under the Equal Protection Clause and the Due Process Clause. And in Fisher v. University of Texas in 2013, the court upheld the use of race as a factor in college admissions as constitutional under the Equal Protection Clause. The United States has continued to move from barbarism to civilization, as Douglas had hoped. We are now ready for questions.
Based on your study of the 14th Amendment, and you made reference to Brown versus Board of Education, can you describe the differences between equality of opportunity and equality of condition?
Can we move on to another question? I don't think we're entirely equipped to answer that.
Sure.
Do you think it was necessary for President Lincoln to suspend the writ of habeas corpus during the Civil War? Why or why not?
I think that it was necessary because, as we mentioned before, the Civil War escalated into obviously the bloodiest conflict in U.S. history, and he had to take whatever steps he felt necessary to ensure that the Union would achieve victory. And I think that that's a perspective that I hold because I'm living right now, and I see slavery as this great evil, and that people at the time probably felt much differently. And I think that's kind of a subjective question in terms of when you're alive, I guess, so to speak.
Yeah, I agree that looking at it from now, like from where we live today, and looking back at it, it was definitely, I think, a necessary step to take.
I would agree as well. It depends on the time frame because if you put yourself in in his shoes, I guess, I think it was a necessary step to take in order to get to where we are today.
Let me follow up on something that Michael said in his opening statement. Essentially, that there's this distinction between process and substance, the procedural rights and substantive rights. And I think a lot of times we think about how those differ, right? Because you want to have categories, and that's how you study. But I'm wondering if you can tell me how maybe they are related. I mean, how do they interrelate? How can they feed off each other?
Well, I think if, like, here in the U.S. we have an adversary system of law in which two sides are pitted against each other really to get to a common good, and you're like innocent until proven guilty, and both procedural and substantive due process both kind of work together in order to make sure justice is found really. And in addition to that, when you look at substantive due process from natural rights philosophy and looking back like from John Locke and how pre-existing government there's these natural fundamental rights basically. And I think that's a big part of it, that both of those coexist together.
I would concur with Ty, and I think just at a simpler level, it's both about the protection of freedoms and just thinking about the best way to go about doing that, whether that's making sure that everyone is given kind of the same procedure to follow, or whether that's just here are things you can't mess with no matter what.
Yeah, I agree. They both work together.
So our Colorado Supreme Court just heard a very important argument last Tuesday, the masterpiece case versus Phillips. What do you think are some of the most important considerations for the court to examine, and what are your thoughts about it?
I think that one's complex, and it comes down to obviously like the Equal Protection Clause versus Free Exercise Clause, and so that decision is going to be a really big deal. And I think whenever the court has to balance two rights against each other, that's when, I think in a lot of ways that's what the Supreme Court's all about, is determining what's like right and moral. And so I think that whatever ends up happening, it's gonna be a big deal, and that the most important thing to consider is if the man is an artist as he states he is, then where does that end? Like, is the florist an artist? And so so on and so forth, and yeah, that would, I think, however that ends up panning out is going to be monumental.
I would agree with Michael. The precedent, or I think this case will become a precedent-setting case for future cases that arise under similar conditions.
Yeah, I agree. It's very
What arguments are you most persuaded by?
Well, so I feel like I'm on the side of the couple, so like I feel like if it is the freedom of the artist, where does it end? Like what Michael said, it just gets very complex looking at it from both sides.
Yeah, and also he as a business owner is offering his services to the general public, and so if he's gonna say to one person, I'll make you a cake, and another person, I'll make you a cake, then it's really a question of religion. You know what I mean? Because he's putting himself out there to bake cakes.
What do you think are some modern examples of, setting aside what we just talked about, of rights, cases that we need to think about as a modern society?
Definitely recent legislation with passing of immigration laws, I would definitely think is a really current example of some of those issues coming up, yeah.
And why do you say
Well,
that?
I'm not sure what clause it is, but something about immigration in the Constitution, and I don't remember where you find it specifically, says person, not citizen. So when you take into account the concept of immigrants coming into the United States, we're talking about people, not, citizens that are protected by the U.S. government. And I think that shifts your entire perspective in terms of like DACA and the wall and all those different things that we've been talking about recently.
Thank you.
Thank you all for your fine presentations. We'll just take a we don't have a lot of time, but we'll just take a few minutes to give you a little bit of feedback. And again, really good job preparing and delivering your speeches. I'll go ahead and start. And I think you had really good teamwork. You guys kind of feed off each other and responding to questions as well as introducing your topic. In terms of constructive criticism, even during the delivery portion of your opening statement, I encourage you to engage your judges by, maintaining eye contact, even if you need to deviate a little bit from your notes. Really nice use of Supreme Court authority. I think that's a really persuasive and really nice way for you to illustrate the point that you're trying to make. It's showing its application. So I think you guys are all fine advocates.
I would agree with a lot of the feedback that she just shared. I would also add that in the question and answer period, make sure to always cite Constitution or what you've studied as reasons for your opinions, not just stating what your opinions are.
Well, I think you were great. I just love this subject, and I love listening to you. First off, I just want to thank you for answering the question, which you may think is like, oh, ho-hum, but you just, right from the beginning, and you trace that history. It was beautiful, just really beautifully done. So thank you for doing that. I also thought your answer to my question was so sophisticated. I teach constitutional law in law school. And I couldn't get that answer out of a lot of my students. So that was just terrific. And one little tip is that don't be afraid to disagree with each other too. I think you agreed with everything, and sometimes you just kind of feel like I gotta agree, but hey, if you don't agree, sometimes that can make a very interesting kind of conversation. So you might think about, I don't know if you're just kind of holding back on disagreement, but if you do disagree, feel free to state that. But I thought it was terrific. I just really enjoyed it. So thank you for letting me be here today.
Yeah, and congratulations for investing this time in yourself and in educating yourselves about the Constitution. And again, kudos to your teachers and your coaches. I hope that this is just the beginning of your engagement with our federal and state constitutional process. We work with the Constitution on a daily basis as judges, and I'm sure you do as well in your advocacy. So good luck, and thank you for allowing us to be part of this process.
Congratulations.
Already exhausted. That was exhausting.
failed to sound so hard. Last
It's very awkward with the camera, though.
Good morning. We'll introduce ourselves and then we'll ask you to please stand up.
My name is Melissa Hart. I am a professor at the University of Colorado Law School.
I'm Ann McGeehan. I'm a practicing attorney and a former state legislator in Denver.
I'm Susan Schultz and I'm a history professor right upstairs. Go ahead and introduce yourselves, please, and your teacher.
I'm Sarah. I'm a sophomore and my teacher is Roberta.
I'm Jamin Tolbert. I'm a senior as well, and my teachers are Roberta and Jen. I'm Todd Grabowski, and my teachers are Roberta and Jen.
Well, great to meet you and welcome to all of you. We're happy that you're here. Dr. Hart's going to read the question.
So we've decided to go with question 1. Most of the delegates at the Philadelphia Convention signed the Constitution on September 17, 1787. However, some did not. What were the Anti-Federalists' objections to the proposed Constitution, and how did their political philosophy shape their objections? How did the Federalists respond to Anti-Federalist objections? What was the ratification process for adopting the Constitution? What democratic principles did it reflect, and how did it succeed?
In 1787, delegates at the Philadelphia Convention were asked to sign the proposed Constitution. In all, 70 delegates were invited to the convention. Of that 70, only 55 attended, and only 39 actually signed the Constitution. The majority of those who did not sign were labeled as Anti-Federalists. The Anti-Federalists had many objections to the proposed changes to the U.S. government. The Constitution would mean the introduction of many new powers given to the national government. Converging around the opposition of the centralized government, the Anti-Federalists were the voice of concern. Their fear was that too much power would be given to the national government and too little to the states. Patrick Henry, a strong voice for the Anti-Federalists, stated, "If the states not be the agents of this compact, it must be one great consolidated national government of the people of all the states." The Anti-Federalists believed that the state could better represent the people and protect their rights because they were closer to the people. True representation was part of the Anti-Federalist arguments against a strong, centralized government. They believed that state representatives would be more invested in the interests of the population due to their consistent interaction with the citizens.
George Mason, a major contributor to the Anti-Federalist viewpoint, stated that the Constitution was totally subversive of every principle which has hitherto governed us. This power is calculated to annihilate totally the state governments. Another big concern of the Anti-Federalists was the necessary and proper clause. Article 1, Section 8, Clause 18 within the Constitution, which states that Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. The Anti-Federalists thought that the proposed Constitution would create a government that wasn't controlled by the people, but instead was controlled by the national government. They also believed that a strong national government, along with a large nation, would be prone to failure like other historical republics. Article 6, Section 2 is called the Supremacy Clause. It states that the Constitution is the supreme law of the land. The Anti-Federalists' strongest argument against the ratification of the Constitution was that it contained no Bill of Rights. Without a Bill of Rights to protect individuals from infringement by the government, the Anti-Federalists believed the national government would act tyrannically, justifying its actions as a supreme law. Addressing the Anti-Federalist concerns, several Federalists responded with the Federalist Papers. James Madison was a key participant in these responses. Referencing the collapse of the previous republic government systems, he argued that the views of classical republicanism would not support the rapidly growing nation. With such a diverse nation, no one entity would be able to command the majority. Having representatives would act as a screening process, enabling the filtration of ideas solely based on self-interest. No single faction would emerge supreme.
With 9 states having ratified the Constitution, the new government could have been enacted. However, the nation could not prosper without the support of New York and Virginia, states which were both highly populated and wealthy. Wanting some sort of compromise, Congress discussed the possibility of adding a Bill of Rights to the Constitution. This would diminish concerns among Anti-Federalists, and Virginia and New York would then go on to ratify. Eventually, North Carolina and Rhode Island also chose to ratify the Constitution. In 1791, James Madison, a Federalist, proposed a Bill of Rights, and it was adopted as the first 10 amendments to the Constitution. Several current day issues continue the debate about states' rights versus federal rights, which correlate with the Federalist and Anti-Federalist views expressed 200 plus years ago. One example, within the current presidential term is the fact that the federal enforcement of marijuana has been increased, contrary to previous enforcement tactics. While recreational use of marijuana has been legalized in several states, it is still considered to be an illegal substance on a federal level. The state laws mirror the anti-federalist beliefs about state supremacy, as the citizens within the state jurisdictions tend to obey their state laws over federal laws. The fact that these issues continue to be debated is captured in this quote by George Washington. On the whole, I doubt whether the opposition to the Constitution will not be ultimately productive for more good than evil. It is even called forth in its defense abilities which would not perhaps been otherwise exerted that have thrown new light upon the science of government. They have given the rights of man a full and fair discussion and explained them in so clear and forceful manner as one cannot fail to make a lasting impression.
All three of you outlined, on the whole, they were right to raise these objections and concerns. Do you see their reservations as legitimate?
I most definitely think that it's important to raise concerns about any issue. Both sides of an argument are necessary in order to create an adequate decision in the long run. So without conjecture or disapproval on one side, nothing would come to light.
Looking at the classical republicanism and natural rights philosophy, there's always been a push and pull between the two, and there's always been debates, and there's always been contrary beliefs to one another. So I think the views expressed at the Philadelphia Convention produce another surfacing of these two viewpoints and how government should be enacted.
The Bill of Rights is a huge part of our Constitution, and we interact with it today. Without that being attached to our Constitution, we may not see large issues that we would have today. So I think the Anti-Federalists raising those concerns and making sure that they were put part on the Constitution for then all the states to ratify was very important.
Considering that the Anti-Federalists were an advocate for the citizens of the United States at the time, it was also important for the Anti-Federalists to bring those concerns to light, since they believed that states could better represent their citizens due to their more close quarters, per se.
So, just sort of following up on this question, if you had been there, would you have been more of a Federalist or more of an anti-Federalist?
For me personally, it's hard to say because, different times require different viewpoints. And at the time, there was no internet, there was none of the large government that we're familiar with, so I wouldn't really know how to base that on. But if I was back there, I would really be more for federalism, because at the time it was a growing nation. They didn't have a treasury yet. They were still starting out, and I think having a strong national government would offer kind of a security blanket for the country to continue to grow and develop economically and socially.
Considering that the Articles of Confederation have similarities between the EU treaties as well, I would be leaning more towards Federalist viewpoint, considering that the Anti-Federalists had, or not Anti-Federalists specifically, but state laws and state governments tended to have more differing opinions and had issues that came along with that. So regulating trade within those states, and it wasn't particularly an issue at that time, but as we see now, immigration as well would be an issue with a confederation. So I would have leaned towards the Federalist viewpoint.
I disagree with my teammates. I would have had a more anti-Federalist viewpoint approaching these. I wouldn't have I would have wanted to put my say in correct anything that I didn't want to wholeheartedly believe in that was already put into the Constitution. And the Bill of Rights is so important, and we interact with them on a daily basis. Like, I wouldn't have wanted to ratify that Constitution without that being a part of it. So I think having government closer to our states in that moment would have been very important. So I would have taken a more anti-Federalist viewpoint.
Let's talk about the ratification process, and you all have chosen Rhode Island as your state. So I wanted to talk about, to have you tell us about the ratification process. What democratic principles did it represent? And maybe a little bit about Rhode Island in that process.
They needed, in the beginning of, when they went to the Philadelphia Convention, they were planning on originally just correcting the articles, and in turn, they ended up drafting a whole new constitution. In order to, work with that constitution, they needed 2/3 of the, 13 states, colonies to approve that. So they had 9 of them. It took 10 months for 9 of the states to ratify. At that point, Delaware was the first. And they could have continued to move on with that constitution. However, they really needed Virginia and New York to get on board with that because they were very wealthy states.
Article 7 in the Constitution outlines the process for ratification. And as George Washington put it, they could have moved forward with the amount of states they already had. However, the social contract theory states that, to legitimize government has citizens' consent, and if you're omitting the wealthiest, if you're omitting the wealthiest and most populous states, you're really not acting as a government that is consenting to the people's beliefs. So they continue to push and continue to advocate for the Constitution in the other states because they needed everyone on board to move forward.
Adequate representation was very prominent concern within the ratification process. So within Virginia and New York, they had fairly populous and wealthy, they were populous and wealthy states. And with 9 states having already ratified the Constitution, they thought that it would be best to have Virginia and New York on board because they felt that they couldn't succeed or prosper as a nation without them. So in terms of representation, there were several things that went into that, particularly the Great Compromise and also the 3/5 Compromise. But those played a very big role in the decisions to ratify for Virginia, New York, and the states.
Go ahead.
Good
job.
We're here to give you some feedback, if that's okay. I think one of the strongest things I saw in this panel was the give and take between the panelists. Right? The fact that you all, I think, answered each question. Right. That's right. That we don't always see that, and that speaks to your not just the collaboration between the 3 of you, but that all 3 of you have prepared on many different sub-questions and areas of analysis. So that's great. I think I'll give you one point of feedback, and that was in the response to my first question is about whether the Federalists, the skepticism that the Anti-Federalists raised was legitimate. You answered in a sort of general way, like it's good to have skepticism, but what might even strengthen that more is to give specific, what was Patrick Henry so concerned about, right? What were the Anti-Federalists formally speaking? What were their specific concerns, right? The extent of government, and you did some of this in your opening, right? The reach of what they called almost an empire,
yes.
Right? State versus national. So a little bit more specificity about the things around which the Treasury, right? The raising of an army. That might, I think, beef up your answer to that kind of question a little bit.
Great job. I thought you really did work well together and used a lot of good evidence. I really liked your emphasis on the Bill of Rights and how important it is today. One of the things that I always note is that a lot of people think the Bill of Rights is the Constitution. Mm-hmm. So, I mean, that's a super important part of the Constitution. Is it Ratha? Ratha, sorry. You recovered well from your anxiety. You should have more confidence. You are great. You had really smart, wonderful answers. So own that. But I thought all of you were really great. So nice job.
Yeah. I thought each of you presented so nicely, and there's a camaraderie between the 3 of you, which is very nice. Although you were going to start to answer that first question, and they cut you off. You need to push yourself.
It's okay, I got my answer in there.
And you did, indeed. That's right. I liked that you mentioned some things we hadn't heard yet, the supremacy clause, for example. I thought that was a good point. And then trying to draw the similarity with what the EU has done was also really good. On my ratification question, we might have talked more about not just the 2/3, but why they were doing that, and was that really representative of the people? So that would be sort of my other piece of it. But nice job, everybody, and I'd like to thank you and thank your teachers. Yeah.
Before you go, I want to add one more thing, because I think we have a second. Do we have a second? Okay. And this is something, I'm going to speak as a historian here. And Rate, you got at this a little bit when we asked, if you were back there at a time machine, would you have been a Federalist man?
Yeah.
And you said something that I cannot stress how important this is, especially today, and that is, it's complicated. I think sometimes we draw too clear an analogy between the past and the present. We're very quick to see the anti-federalists only manifest in the Tea Party. But for instance, who's arguing state rights right now, right? Well, it's the people who are out of power. And so things change very quickly, and I really encourage you to explore that complexity and to realize that it's not simple, right? That's all. That's my teacher, my professor.
On that, I loved using the marijuana example. I
Yeah,
thought that was really
that's
good.
exactly it. Who's arguing state rights now, right?
Yeah.
It's complicated. So anyway, thank you.
Congratulations.
Thank you.
Nicely done. What's your time in?
Thank you. You can all go ahead and be seated. All right, good morning. We're going to go ahead and introduce ourselves, and then after that, if you all wouldn't mind introducing yourselves, and then tell us something you like to do other than this, which is, of course, the highlight of your year, I'm sure. I'm Suzanne Steyert. I'm the Deputy Secretary of State. I do a lot of election law, campaign finance, that kind of thing.
My name is Rita Burns-Kittle, and I'm a senior trial attorney at the U.S. Equal Employment Opportunity Commission. So I litigate employment discrimination cases in federal court.
I'm Josh Wilson. I'm a professor here in political science, and I study conservative movements and their use of the law.
I'm Layla Puyer. I'm a junior, and something I do outside of this. I don't know. I really enjoy this. I want to be a civil rights lawyer when I grow up, so I really enjoy doing all of this.
My name is Sierra Ventimiglia. I am a junior, and I really enjoy studying emotional philosophy.
I'm Owen Jennings. I'm a senior, and I'm an avid reader.
All right, we are going to do, we're on Unit 1, we're going to do question 2, which is really long, so if you have plenty of time to get your notes together. Greek and Roman history has revealed that thinkers such as Plato, Aristotle, and Cicero thought that all democracies may begin well, they tend to end in tyranny. What was Aristotle's thinking about different forms of government? Which did he prefer, and how might his ideas have influenced the framers of the Constitution? In what ways, if any, does our government reflect Aristotle's idea of polity? How are the ideas of classical republicanism and natural rights philosophy reflected in our government?
Throughout the span of history, there have been many hypotheses presented on the nature of government, but among these theories, there are several that have had profound impacts. Plato's writing, as contained in the Republic, stand out, as they set a precedent for and go into great detail on what it means for society to be just, and on the model of government that would be most just. Aristotle, Plato's student, tended towards favoring a kingship.
In Aristotle's work, Politics, he details his theories pertaining to different models of government, describing 3 correct regimes: kingship, aristocracy, and polity, as well as deviations from these 3 regimes: tyranny, oligarchy, and democracy, respectively. Later in Politics, he goes into detail of each of these governmental models. However, the one that fits best into the groove of America's governmental founding was by far polity, defining it as when the multiple governs with a view to the common advantage. After going into depth upon the nature of polity, Aristotle went on to describe the rest of the regimes, relating their just applications in the situations that should surround them when or if they are applied. During this, there were several moments where Aristotle's influence on early American government stands out. One of these occurred when Aristotle went on to describe governmental model, relating 3 important roles that must be fulfilled by a government, the roles being the application of a judiciary, an executor, and a legislator. These exact roles, or branches in our case, were set forth by the framers when they went on to write our Constitution. Aristotle went on to further define polity as a mixed constitution, believing that the best form of government would combine both oligarchy and democracy. In his terms, this would be the rule of the enlightened few, or those best fit to rule, combined with the rule of the many. We can see this viewpoint reflected within Article 1 of the Constitution in terms of the mixed forms of representation present in Congress. The framers intended for the Senate to be the rule of the best and brightest, thus adhering to the oligarchical component of Aristotle's mixed constitution, while the House would represent the people. This is further reflected through the mode of representation upheld in both the House and the Senate, with the Senate maintaining a consistent number of seats per state, and with the House having a number of seats representative of each state's respective population.
Cicero, a Roman philosopher and scholar preceded by Aristotle, put forth his own ideas on government, speaking about the need for moral obligations to be held in high regards to civic responsibility. Cicero is considered a significant influence for the framers, with Jefferson referring to him as one of the few who contributed to a tradition of public right, which informed Jefferson as he wrote his draft of the Declaration of Independence. In addition, his writings have been credited with greatly influential post-Renaissance philosopher John Locke as he went forth to write upon the natural rights philosophy. Natural rights upholds many things that Locke believed related directly to human nature, and the inalienable rights that should be assured, chief among these being the individual right to life, liberty, and property, a line remarkably similar to one of the most well-known in our Declaration of Independence: life, liberty, and the pursuit of happiness.
To natural rights philosophers, these rights were supposed to be ensured and upheld by the government as part of the social contract. These ideals went forth to support and in part create what was then liberalism, a political school of thought valuing limited government and the rights of the individual. Natural rights was not the only important contribution by Locke. Locke was also a staunch advocate of classical republicanism, particularly when it came to the continued evolution of democracy. Locke shared this appreciation for classical republicanism with several of the framers, namely Jefferson and Madison. Classical republicanism valued civic responsibility, furthering the common good, and stated that human beings should be driven by civic virtue, in contrast to natural rights philosophy's stance, which was that human beings are innately driven by self-interest. In classical republicanism, the government's role is to further the idea of the social contract, saying that the job of government is to promote the common good, and the citizens are responsible to participate in government, namely the voting process. The importance of voting is at the heart of the social contract, particularly when it comes to the preservation of democracy.
So Aristotle also said the rulers should be chosen not solely on the basis of their merit, but also on the basis of their wealth, since poor people cannot afford the leisure necessary to rule well. So is this a concept of Aristotle that you agree with it? Is it reflected in our government? Were the founders influenced by that?
Personally, I believe that, I don't believe in that. I believe that everybody has a very different point of view, and someone's wealth should not be influenced by that, should not be influenced by if they are fit to rule. But I do think when forming the Constitution in our voting process, it was only white men who owned property that could vote. But this was also a very long time ago, and I believe that Aristotle's philosophies as well as our Constitution are very applicational, and they evolve and are interpreted different throughout the times.
So Aristotle stated that he believed it was very important, the mutual exchange of goods was very important, and this spoke a lot to our modern day entrepreneurs and the internet, for example. A lot of the stuff he spoke to, such as this, cannot be achieved without some area of wealth.
I'm with Leela on this one. I think that everyone should have an kind of equal opportunity in order to achieve life, liberty, and property, essentially.
Aristotle also believed that those who should be voting should be well educated on the subject that they are voting on. And at the time he was around, the people who were educated in the subject of ruling or government were the upper class and were those who had the wealth to afford education. So in that case, the poor were not capable of funding themselves to have a proper education in most cases. But now, because of our education system, we have an opportunity for all people of all varieties of wealth to be educated on the topic. So I think it's important for all people, both rich and poor, to be able to participate in government.
So one of the ideas that you brought up in your opening statement is the idea that limited government is what leads to freedom. It was kind of where you ended off. But we also have this idea that human nature is deeply problematic, right? So I wanted to hear a little bit about how you guys reconcile those two things, whether they can be reconciled, or if you think that a greater state of freedom would actually come from more state intervention as opposed to less, given the problematic state of human nature.
Yeah, so I believe what you're stating is very similar to natural rights philosophy and classical republicanism, and kind of how those two combat. The natural rights philosophy has a lot to do with what you were stating, which is kind of the idea that human nature is at its best when people are in like their natural state, and classical republicanism goes more from the viewpoint of people have a responsibility and a moral obligation to serve for the government and the common good. And this.
Yeah, so Turk had the idea of self-interest, and that if people get together as a group and work for the common interest as a group, that it will also benefit themselves. Mixing the value, the right of association, the freedom of the right of associations, and the value of civic virtue. And because of this, sorry, excuse me, I completely lost my train of thought. So I believe that it is very tricky, but I do believe that human beings are not automatically programmed to go a certain way. I do believe that if we all work together and work for the common good as a group, that we all will benefit our self-interest.
As Leela,
Oh, no, go ahead.
As Leela was saying, Alexis de Tocqueville believed in a kind of meshing of natural rights philosophy and classical republicanism, which was both the idea that people are inherently going to serve their own interests, but at the same time, it's also important for humans to participate in the greater good of the community and to uphold that idea of civic virtue. So he believed that by participating in bettering the community, that you would then be furthering yourself. So I think meshing of the two could definitely be valuable.
So you've all talked about this notion of civic virtue, and we've already talked about how we've opened up beyond white male property owners. Has that resulted in more civic engagement? And if not, then do you have ideas of things that should change, things that we could change structurally that would increase civic participation?
I think it's always important to have the diversity of opinions presented at the table. So when you have one demographic leading a population that is not made up of solely that demographic, then obviously the results are going to be skewed towards that one group of people. So if you have minorities present at the table, if you have even people of the other gender present at the table, then you're going to be able to get results that are going to make all kinds of people happy.
Exactly. That also kind of goes off of the whole self-interest idea, that the more people that you bring to the table, so minorities, people of lower income, the more say that they have is the greater for the common good, and it also lets people achieve their own self-interest.
This is also a really good reason why states having power is important, because with how much our population has increased over the years, you have so many different kinds of people, and it's hard to sum that up within one federal government, which is where we see in the laboratories of democracy, where you have states that come up with their own laws, and it can eventually lead to the bigger federal government that we're in. Thank you.
feedback?
Yeah.
Okay. Sorry, I have to like put together my own notes that I've given you. But to start off, again, I liked the pace that you guys had. It was very easy to follow your guys' argument over time. I also particularly liked that in your opening statement, you did a good job of linking thinkers over time to actual structures of government that we have in the present day. So it's really good that that's the kind of the challenge probably of section 1 or whatever we're called, is linking things that many people don't kind of naturally connect in their head. So you did that nicely. I also really like in the Q&A that you immediately, with this very problematic or interesting Aristotle quote, that you attacked it head on. But this is my favorite kind of answer over the Q&A, is that you pointed out immediately what was problematic about it, but then you worked your way back to also situating it within context and then maybe finding generalizable points that were salvageable from it. And so I thought that was a really nice job of taking a new quote and actually working through it. So you did a really good job there. My one criticism would actually be on, admittedly I gave you guys a difficult question. And it's easy to get kind of caught in a difficult question. The one thing is you didn't answer the main part of the question, which is I wanted you guys to get at the nature of freedom, right, and its relation to the size of government, right? It's good you started off with kind of these ideas of let's talk about the thinkers and how they might get there, but I think you kind of lost where you were going over the course of it. So in Q&A, if somebody gives you a long, rambling, multi-part question, try to really identify like what's the central point here, hit that, and then maybe move out from there. I did though really appreciate the coming back to Tocqueville at the end, because that's a useful way of getting at this.
So I agree with all those observations. I thought you did a very nice job. You guys clearly know your material. You're responsive to the questions. You shared the space equally. It wasn't like one person was dominating. So I thought, and you had a very nice presentation. It felt like a conversation with you. My one criticism is that I think you could benefit from, in your opening statement in particular, but also in your follow-up questions, from more reference to case law that gets at some of these points, and some citations to the Constitution itself. You talked some about like the structure of the House and the Senate, but there's some additional references to the Constitution that you can incorporate, and some cases that you could learn from just by studying the facts and how they were decided.
Thank you.
Thank you.
Yeah, I thought you all did a great job as a team. You obviously worked well together and had a really good flow. Probably the same thing, if anything, that when you have follow-up questions, try to listen to the question and attack it head on. I think you did a really good job on the first one, and then like my question was about basically we have more people in the process, but we have less people participating, if that makes sense. Maybe I should have worded it that way, but we see voter participation go down even though we keep increasing opportunities to vote. So how do we fix that? And I think you all would have done a good job taking it head on. But one of my pieces of advice that goes back to the cases is a lot of times there are cases that, as long as you know them, you can probably bring them up for lots of different kinds of questions that people have. And it's just good to have kind of one on the tip of your tongue so that you can relate it back and, do it that way. But yeah, I thought it was a great job. I really enjoyed the introduction too. All right, thank you.
Thank you.
And thanks to your teacher and all your parents.
Yes.
And congratulations for making the mistake.
Thank you.
It's an accomplishment.
Thank you, sir. Thank you very much. Thank you. Pleasure. Thank you.
Nice job.
Thank you.
I'm not the judge.
we ready to begin? Great. Well, my name is Ryan Drysdale, and I'm a facilitator, and we will have our judges come in shortly for Unit 6. And please make sure all cell phones are turned off, and we welcome the judges.
Hi, everyone.
Morning.
Have a seat, please. Welcome to the Colorado Finals, Unit 6. My name is Carl Kurtz, and I am retired from the National Conference of State Legislatures, which is headquartered here in Denver. And I'll let my colleagues introduce
I am
themselves.
Christine Hilbert, Executive Director, newly retired, of the Boulder County Bar Association.
And I'm Lori Boris. I'm a judge on the Colorado Court of Appeals.
And would you introduce yourselves and your teacher?
I'm Brenna Giblin, and our teacher is Roberta and Jen, our teachers. I'm Caroline Peterson.
My name is James McDermott.
Good. Are you ready? Deep breath. So your question is number 3. Give me your tired, your poor, your huddled masses yearning to breathe free, the wretched refuse of your teeming shore. Send these, the homeless, tempest-tossed, to me. I lift my lamp beside the golden door. These words engraved on the Statue of Liberty embody America's acceptance of immigration. Why, then, has immigration been a problematic issue throughout our history? What are the major cultural and political issues regarding immigration facing America today? What changes, if any, should be made to our current immigration policy? You may begin.
To welcome all immigrants is a core principle of American democracy, yet it has been contradicted throughout history by xenophobia. This fear has led to policies that are unfair and contrary to the nation's founding principles. Accepting Article 1, Section 8, Clause 4, which gives Congress the authority to establish a uniform rule of naturalization, the power to regulate immigration is not specifically outlined as one of the enumerated powers. In early immigration cases, the Supreme Court struggled to identify the source of the federal government's power over this matter. At first, courts pointed to constitutional provisions, like Article 1, Section 8, Clause 3, the Foreign Commerce Clause, to support the inference that the federal government holds complete power of immigration. In the Chinese exclusion case of 1889, the Supreme Court decided that the power to regulate immigration is inherent in national sovereignty, rather than stemming in from any specific constitutional provision. This citation became the foundation of immigration law, and because it is extra-constitutional, the court came to the conclusion that the judiciary had little or no role in reviewing decisions which prohibit immigrants from entering the country, nor in reviewing decisions to deport non-citizens. And so, the plenary power doctrine, which gave seemingly limited power over immigration to the executive and legislative branches, was born. A 1952 provision to the Immigration and Nationality Act describes the scope to the doctrine. It says, the President may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens and any class of aliens, as immigrants or non-immigrants, whenever he or she thinks it would be detrimental to the interest of the United States. Nothing was in place to stop the federal government from upholding the Chinese Exclusion Act of 1882, from banning communists from entering the U.S., or from establishing the discriminatory national origins quota system. The granting of plenary power is reinforced in many cases, such as in Knopf v. Shaughnessy, where it is ruled that whatever the procedure authorized by Congress is, it is due process as far as an alien denied entry is concerned. This statement describes consular non-reviewability, which gives visa denials by consular officers protection from judicial review and gives no right of appeal. Immigrants have a right to due process as outlined in the 5th and 14th Amendments, as well as a guarantee to equal protection as given to all people, regardless of legal status, by the 14th Amendment. Although the nation began to move forward in terms of equality during the Civil Rights Movement, the plenary power doctrine, an antiquated vestige of former times, has remained. Though it has been limited over time by the courts, this doctrine leaves a dangerous loophole that could allow for blatant discriminatory policies to be reimagined. The issue has been brought to light more recently amidst controversy over President Trump's original travel ban from 6 Muslim-majority countries. The ban was shot down by the Ninth Circuit Court of Appeals because the order did not provide a rationale explaining why permitting entry of people from the 6 designated countries would be detrimental to the interests of the United States. Arguably, if President Trump had rolled out his plan in a more organized manner, the original ban might have been allowed despite it being an obvious violation of the First Amendment.
In the 1977 decision, Fiala v. Bell, the court observed, in the exercise of its broad power over immigration and naturalization, Congress regularly makes rules that would be unacceptable if applied to citizens. To ensure equal protection for all people, the plenary power doctrine ought to be addressed by the Supreme Court. There are also more subtle aspects of discrimination in our current immigration policy that should be changed. For example, per-country limits give an unfair advantage to immigrants from smaller countries. Adult children of U.S. citizens from large countries like Mexico wait an average of 7 to 21 years for a visa. Immigrants should be treated equally as people, not as representatives of countries. We should establish a system which functions on a first-come, first-served basis with a priority for refugees given their struggle with human rights violations. Being completely intolerant of discriminatory policy is key for the future of our nation. President Trump ran his campaign on a promise to build a wall between the United States and Mexico. Anti-immigrant sentiments are becoming more and more visible in the United States. As a country, we have made huge leaps towards equality, and it is now time to ensure that fear and discrimination are not the foundation of any immigration policy, now and into the future. We're now open for questions.
Thank you. So do you think we should encourage new immigrants to become U.S. citizens?
I think so. For immigrants who are planning on staying here for the majority of their lifetime, I think it's an important aspect for them to be members of the community and participate in the common good and strive for all those civic liberties that comes from being a U.S. citizen.
Would you make any distinction between legal and undocumented immigrants in that regard? Does your position support that regardless of their legal status?
I see voting as one of the key democratic values, and because immigrants who don't have a citizenship but do have a legal status can't vote, I think that it's important for them to pursue citizenship because it's such a key value.
In that case, being said, I don't think that we should determine the eligibility for citizenship based on if they're illegal or legal immigrants, because as part of the Constitution says, the United States is to promote liberty, life, and the pursuit of happiness, and we can only allow that when we let everybody pursue liberty, the pursuit of happiness.
In theory, the Constitution only makes three distinguishes between citizens and non-citizens. That's the right to vote, the right to hold certain government positions, and the right to bear arms.
In your opening, you were talking about Congress or federal power to control immigration. Should state governments have the power to regulate immigration? Why or why not?
I believe one of the reasons we decided on a larger federal government was so that the federal government could have power over things such as immigration and foreign commerce with other countries. And I believe that is important, an important power for the federal government to hold. Otherwise, states could discriminate against certain classes of aliens, and it might be hard for aliens to get across state borders, and that would not be what America is about.
Local government is often a more effective way for the government to become closer to the people. And in cases like immigration, Florida, California, and Minnesota are all going to have different ideas around immigration just because the issues they face are going to be different. So it might make sense that the people of Florida should be deciding immigration from the neighboring countries rather than the people in Minnesota and throughout the country where it's not as impacting them as much.
Given what's happening in the world with all the displaced people, do you think that the United States should expand their acceptance of refugees, or what should we do about that?
My personal belief is that the U.S. should have an open border. However, I recognize that that's not a popular opinion, and so I can compromise on that issue. And I think that the U.S. has a large responsibility in many of those foreign affairs, and so I think it's our duty and our responsibility to ensure that refugees from striving countries have those rights protected. And the Bill of Rights, it protects rights for the natural rights inherent in being a person, not being born in the United States, but just for being born. And we should uphold that and strive for that greatness.
Can you give me very quickly the principal argument in favor of renewal of DACA and the principal argument against it?
The principal argument against it would be that people would be worried that those immigrants would become radicalized, or their children would become radicalized, I suppose, since DACA is for the children. And that would be the principal argument against.
for the people already in power, the people in DACA would be able to exercise the right to vote potentially, and that might affect the amount of people who are in power and change that. So I think that representatives are biased towards not wanting to change their constituent population.
What argument does President Trump use about it?
I think that President Trump's major argument is one of economic base, that an increase in immigration is detrimental to the economy. But there are many, many studies that demonstrate that an increase in immigration actually increases the GDP, and immigrants start small businesses. 25% of new patents are registered by immigrants, so there is a lot of evidence that shows that immigrants actually bolster the economy.
Speaking of the economy, many companies use outsourcing or sending work to out of foreign nations. Do you agree or disagree with that policy, and do you think it has any effect on immigration?
The majority of the reasoning for outsourcing is because it makes the labor cheaper, and therefore the CEOs can get a bigger return on their investment. And I think it was Robert Dahl who said that democracy lies most comfortably with market capitalism, and that market capitalism thrives on inequality. I think that's an example of a capitalist society having an economic system which favors the rich getting richer and the poor getting poorer. And that's an example of the wealthy people exploiting the poor for their labor. And so we should prevent that.
I don't believe it has any effect on immigration in the sense that these are corporations, and immigration tends to be individual people coming into the country.
Okay, well, thank you very much. Good job. Who wants to lead off on giving feedback?
I'm happy to lead off. Excellent job, and we're always so impressed and appreciative of all the time that you put together, the way that you go back and you use each other, and that's really an important part of this, of being a team. I think you should have known a little bit more about the Dreamers and the DACAs and the 14th Amendment. I think that might be something that was an important part of all of this. Other than that, I think your historical knowledge of the Constitution was good, and that you did a great job. And thank you.
I agree. Awesome job. I thought it was interesting when I asked about the state's control that you kind of focused in on the advantages that a local interest can provide to an issue. It's probably a good point at that point to also think about some of the practical problems that it would cause, such as free movement between the states and how hard that would be to regulate if some state is, say, easy on immigration, and then those people that at some point moved to states that didn't have that much of a desire to have immigrants into their state. Also, I thought it was really good, James, when I asked the kind of tricky question about the outsourcing. It's a little off topic, not horribly, but I think that you were good because you kind of reached back and thought about the whole purpose of what outsourcing is for and used that as the basis for your answer. And that's a great technique to use. If you get confused by a question, think about the basics of what the principle involves, and then fall back on that, and then you can kind of expand on it, which you do a great job doing that. So excellent job for this team.
Yeah, nice work. I too liked your frequent reference to court cases and the history. I thought you were good on the rights of non-citizens. This is an interesting thing we hadn't heard from any other groups. Politically, on DACA, the argument President Trump makes is a procedural one, which is that it's up to Congress to do this, not up to him, and that President Obama did it illegally. So, but from my standpoint, the policy side is more important, and you did touch on that. So, very nice job, and congratulations to all of you and to your teacher.
Thank you. Thank you. Thank you. Thank you.
Thank you so much. Appreciate it. Thank you very much. Good job.
Thank you.
Good luck. Thank you. All right, good job, you guys. Well, let's all rise. The judges are here. Judges? And congratulations to you, Rhode Island.
Welcome, Rhode Island. Please be seated. Well, you've had several panels go before you, and therefore all nerves are completely dissipated and ready to have a casual conversation with your judges. Is that correct?
Absolutely.
Put that down as a baby. All right, as we are to be your judges, you should know who we are. I'm Les Volpe, I'm a Denver attorney, and my colleagues are.
I'm Leslie Herod. I'm a state representative. I represent Denver, Colorado at the state capitol.
Good morning. My name is Rich Gabriel, and I'm one of the justices of the Colorado Supreme Court.
And if you would please, would the panel introduce themselves?
I'm Calvin Walter. I'm T. Giles. I'm a senior.
I'm Sonia Vargas, and I'm a senior. It's nice to see you again, Mr. Paul.
Good to see you too. Okay, let's get right to your question, panel 5. It is question 3. I will read it to you. How has the Fourth Amendment's protection against unreasonable search and seizures changed throughout American history? What exceptions to the Fourth Amendment requirement of a warrant has the U.S. Supreme Court established? What are the advantages and disadvantages of the exclusionary rule? Timer ready? You may begin.
The Fourth Amendment to the United States Constitution sets forth that the right of people to be secure in their persons, houses, papers, effects against unreasonable search and seizures shall not be violated and no warrant shall issue, but upon probable cause. This indispensable right was one in which the founders strongly believed. The importance of these protections had been the subject of debate for centuries. In 1604, Sir Edward Coke stated that the house of every one is to him as his castle and fortress, as well for defense against injury and violence as for his repose. This sentiment was then reiterated by James Otis Jr. in 1761 in his fight against risks of assistance imposed by the British rule. These general warrants, along with the British trade laws, were two of the main catalysts to the American Revolution.
For much of the 19th century, the Fourth Amendment remained similar to its original doctrine. The first time the Supreme Court addressed the exclusionary rule was in the case Weeks v. United States. Here was held that evidence cannot be admitted if it was seized illegally. In the 1949 case, Wolf v. Colorado, the court applied to the states the Fourth Amendment protections, but specifically withheld the incorporation of this exclusionary rule. 12 years later, the case Mapp v. Ohio restated the importance of the relationship between the Fourth Amendment and the exclusionary rule and applied it to the states, overturning Wolf v. Colorado. In the opinion by Justice Tom Clark, it was stated that if letters and private documents can thus be seized and held and used in evidence against a citizen accused of an offense, the protection of the Fourth Amendment is of no value.
Throughout history, the Supreme Court has established a number of exceptions to the Fourth Amendment's warrant requirement. In the 1968 case of Terry v. Ohio, the court established the constitutionality of weapon stops and searches or frisking under reasonable suspicion that the person is armed. In the 1969 case of Chanel v. California, the court held that it is reasonable for an arresting officer to search the area immediately around the arrestee in order to remove any weapons that could be dangerous to the officer in order to recover evidence near to him that could be destroyed. In the 1985 case of New Jersey v. TLL, the court concluded that school officials may conduct a search of a student where there is reasonable suspicion of criminal activity. A number of Supreme Court cases have established the rule that no warrant is required to search when someone with actual or believed common authority consents to it. The case of Horton v. California gave rise to the precedent that an officer can seize evidence when it is in his or her plain view and the officer is lawfully present. The court has also established numerous exceptions under the umbrella of exigent circumstance.
In the case of Olmstead v. United States, the court had dismissed the exclusion of evidence obtained via wiretap, holding that the Fourth Amendment protection only applied to tangible effects. However, in this 1967 case, COTS v. United States, the court held that even though there had been no physical intrusion, wiretapping still violated COTS' reasonable expectation of privacy, changing the definition of what is protected under the Fourth Amendment. The Fourth Amendment protects people, not places, wrote Justice Potter Stewart for the court. Carpenter v. United States, a case currently before the court, will decide whether or not phone records can be seized without a warrant. While the protections of the Fourth Amendment have always been important, the ever-adapting nature of technology makes it all the more important to treat the Fourth Amendment as a guaranteed, indispensable freedom.
In modern times, the exclusionary rule and the Fourth Amendment have become irreversibly intertwined. Critics of the Fourth Amendment argued that there is no societal benefit to letting guilty persons walk free, and that the rule could cause police to conduct searches in an overly conservative manner for fear of repercussions. However, we argue that the potential for a chilling effect on police conduct pales in comparison to the potential for exorbitant disregard of Fourth Amendment protections on search and seizure. The unanimous Weeks opinion stated that if evidence were admitted, the Fourth Amendment might as well be stricken from the Constitution. Should the exclusionary rule be disregarded, the affront to American civil liberties would be egregious. We are now ready for questions.
Thank you. Does the Fourth Amendment protect just your home, or does it protect areas outside your home, your barn, your yard, those kinds of things? Does the Fourth Amendment protection extend outside your home?
The Fourth Amendment protects people, not just places. So as you as a person anywhere, the Fourth Amendment will protect you.
Yeah, so in your reference, I would go back to the case of CATS v. United States, where CATS was using a phone booth to transmit illegal gambling activities, and the court found that this was protected as a tangible effect, like in your home would be.
So I really appreciate your discussion around the exclusionary rule and possibly the effect that it could have on police conduct. In applying that to the stop and frisk policies, do you believe that stop and frisk violates the Fourth Amendment, and how is that played out in police conduct, specifically around racial profiling and that?
I believe that there's a balance between protecting officer safety and apprehending suspects who are performing illegal activities. And I think oftentimes with Terry, this can result in racial profiling, whether intentional or otherwise on the police officers' parts. I do think that the legal basis of the Terry stop is sound, but I do think that there are issues with it, with racial profiling.
All right, Sonia, you mentioned wiretapping in the Carpenter case that's in front of the court.
Yes.
I'd be interested to know what you all think about whether there is a reasonable expectation of privacy in your location. So that's the kind of question that the court's looking at. In that case, we've had GPS devices on the bottom of a car. What do you think the right answer should be? Where's the balance?
With the Carpenter case and location, a lot of people nowadays just use their phone and the location's always on. And I believe that we shouldn't be violating that right, even with like location and whatnot. And I believe, with my opinion on this case, is that I honestly don't know what they did for the final ruling, but I believe myself they should not have used that evidence because it is a violation of their privacy and their location of where they were.
I believe that the Carpenter case will become a landmark case just because everyone has a cell phone now, so it would be really easy for a government to abuse the power to know where everyone is at every time.
One thing I will say is that the argument against the argument for why evidence like this should be able to be seized without a warrant is, I'll compare it to bank records, and that bank records are often seized by the FBI without a warrant. And an argument could be made that these phone records should be handled in a similar way. But I do think that the location data of U.S. citizens is just so personal and so important to uphold that position.
If I can follow up, is the issue just that they've collected data, or would it be, for example, if I just am asked to testify, tell me where Sonia was on this day and that day and the next day, would that violate the right to privacy? So what's the difference? I think I could just testify, I know where she is every day. Is the issue the data collection or what?
I would say that the issue, yeah, I would agree that the issue is the data collection, that it's just such irrefutable evidence, and it's just so, it's just important that this type of super personal evidence be given the utmost importance and respect of the law.
In terms of modern technology, may prosecution authorities fly over your house or ranch or farm at a level of 400 feet and look at what's going on down there and come in and arrest you and seize evidence based on that?
There is actually a case about that, and I believe that is the Kylo case. And that they did not have a warrant with that case, and so I believe with that they shouldn't be allowed to be flying over your house and seizing evidence by spying on you, basically. That's just an intrusion of your home as well.
So yeah, in that case, the court did rule that that these heat images taken over the house in question were a violation of Kylo's privacy.
And along those lines of privacy, as students, do you feel like you have or should have right to privacy in your school? And also, does that extend to your cell phone in school, your lockers in school, your bags in school? Can you talk about that?
In the landmark case of TLO v. New Jersey, it sort of took away a little bit of students' right to privacy because it sort of gives power to the teacher with only reasonable suspicion that they can then search like your immediate vicinity, like if it's check your bag or your locker. So that sort of lessens students' right compared to the adult.
I do agree with the court in that case that there is a lower standard of, there should be a lower standard of evidence when searching students in a school setting.
And then to follow up on that then, when it comes to things like Facebook or Snapchat, that information is public. Do you believe that that information should be able to be used against you? Specifically, we talked about location. Well, location data is public on apps like Snapchat. I'm sure you guys are familiar. What do you think about that?
What I believe about that is we are freely saying where we are. There's that.
You may finish that sentence.
With social media, we are freely saying what we want to say on there, and we are freely giving our location out to our friends and whatnot. And that is you giving up your own right to that. So I believe that is it.
How about a round of applause? I enjoyed your presentation. It's obviously you've worked very hard this semester, and I congratulate you. Just having you know these kinds of things gives me a lot of faith in the future. I would give you this admonition, and that is take your knowledge forward into your future lives. And I've told the other teams, and I'll tell you, if you ever miss a vote for which you are qualified to vote, I will come back and haunt you. Even if I'm dead and gone, I will find you in your dreams. You are now the educated part of our population, and you owe it to the population to go and become politically active and to use your knowledge. And thank you for that. A couple of things. I enjoyed a statement about my opinion is. I haven't heard that today, and I enjoy hearing that from someone your age about what your opinion is. I would give you a little bit of correction. I want you to go back and check on the Kilo case again, because what the court ruled was flying over at 400 feet, you have no expectation of privacy because private aircraft can fly over 400 feet. Any plane can fly over the place. And so what is visible from public space has no expectation of privacy. So check Kilo again. But anyway, when I asked about the protection of the area around, there's a concept called curtilage. And it does extend to areas outside your home. And I think you would do well to be aware of that. Certainly, your list of the exceptions to the Fourth Amendment requirement of a warrant were thorough and detailed. And you had good understanding of the case, Weeks, Wolf, Mapp, Katz, Carpenter. Carpenter was argued 10 days ago, and here you are talking about it here in this hearing today. I think that's amazing. I enjoyed the reference to Sir Edward Coke in his 1604 ruling in the case was Semayne's case, S-E-M-A-Y-N-E''S case, 1604, in which he said a man's home is his castle and it is his last refuge. I thought that was very impressive that you knew that history. I'll turn the rest of the comments over to my colleagues.
I thought you guys did a very, very good job, so thank you for coming so prepared and for all the hard work that you've done on this. It's very clear to me that you have spent a lot of time understanding this issue and these cases that surround it, so I appreciate that. I too really enjoyed the historical context that you guys gave in your opening. I was going to give Les a hard time if he didn't mention that, because it was really important to see how we've progressed as a society and where the laws stem from. But then also your application of current and modern technology, right? And how this really applies to your specific everyday life. I think it's really important and it shows really good critical thinking. So kudos on that too. I liked how there might have been an example given and then someone else was able to then give the case back up. I thought that showed really, really great teamwork. And so continue to do that. That's really strong. And then also just continue to analyze those cases. Think about not only what case can be a great example to prove your point, but maybe what some of the downfalls are as well. Do a little more analytical thinking around those cases. I think that's always really important because as you apply it to what's going on today and your everyday life, you kind of can see the nuances. And I think you guys did show that pretty well as well. So thank you for all of that.
Yeah, I get to go third, so I repeat all my friends said here. You did a wonderful job. Your knowledge of the case law was very, very impressive. And I say this to other groups, as a judge, it's impressive to me, for me to come in here and see folks like you who know more law than many lawyers do. And it was really, really impressive. I thought your teamwork was quite good. You played off of one another well, particularly in your opening. It was a very logical progression to start with the history and then go and then here's what the laws, here are the exceptions. I like that a lot. That really worked very well. There's at least a couple of instances where you kind of gave both sides. I think that was very effective, and I like that a lot. I guess I would echo a couple of just constructive feedback for you. Slow down, particularly in your opening. You're all nervous. It's human to be nervous. When I was in court, I used to write on the top of my outline, slow down. I'm from Brooklyn, New York. I can talk really fast. So be aware of that. And I would say in your opening in particular, try to make more eye contact. You're all reading a little bit much. And so, look at us. We're just human. Talk to us and be comfortable. You know this stuff. Those notes are a crutch. You don't need them. You could probably have all made your presentations without looking at a single note. Be comfortable because you got it. So I would suggest that. Echoing with what Representative Harrod said, on the case law, just as constructive feedback, you could drill down a little bit more. You would cite a case and tell us what it said, but to tell you why this makes sense and kind of giving a little more to that would be, I think, quite helpful. When you said in your opening the issue about there's a cost to the fourth, and when we exclude evidence, there's a societal cost. Is that a good thing? And you answered that question. You said, I think we got to vote on the side of civil liberties here and someone's rights. I was waiting to hear the why. That's a very deep, difficult philosophical question, and I think it would. So you handle it really well. But a couple of times I would have said why. Like when I'm sitting in court and we ask questions, and that's my favorite question. Why? Why should we do that? And so just think about that. It just gives more depth to your analysis. But I thought you did a great job. You should feel very proud. Your teachers and coaches should feel very proud, and I'm proud of you. So congratulations.
Thank you.
Let's recognize you didn't get here all by yourselves. Let's recognize your very hardworking teacher. Good luck in the competition.
Thank you.
Thank you.
Thank you.
Great job. Look forward to
Thank you.
Nice job.
It's all right.
Nice work. Thanks.
Congratulations on being here. I'm the facilitator, so you don't have to impress me. I'm already impressed that you're here. So if you want to rise, your judges will be in.
Good morning. Good morning. Or is it afternoon now? Let's take a look. Please be seated. Well, welcome everyone to Unit 4, and congratulations for arriving at this stage. You know, it's really a pleasure for us to take time out of our day to spend some time with the future. All right, so much of our time is, I think, focused on the present, so we're excited to be with you this afternoon. We're just going to do some quick introductions. We'd like to hear introductions to the panel and your teacher. Let's start here.
All right, I'm Nancy Lichtenstein, and I am a judge on the Colorado Court of Appeals.
Good morning, I'm Dan Taubman. I'm also a judge on the Colorado Court of Appeals in Denver.
Good morning, my name is Anthony Graves. I serve as the Director of Regional Affairs for the City and County of Denver in the Office of the Mayor.
My name is Charlie Erickson, and our teachers are Roberta and Jen.
Hi, I'm Glenn. I'm a sophomore.
I'm Jody. I'm a senior.
Excellent, great. Okay, well, let's go ahead and get started here. How have the role and powers of the U.S. Supreme Court evolved since the founding period? What methods of constitutional interpretation do justices commonly use to decide cases? And to what extent, if any, has the court promoted both the common good and individual liberty? You may begin.
Since the founding period, the court's role in our democracy has expanded significantly. Article 3 of the Constitution established the judicial branch, providing it with the power to establish lower courts, define original and appellate jurisdiction, and determine treasonous acts. It has been widely recognized that the powers of the Supreme Court are not limited to those established in the Constitution. These implied powers, like judicial review, were deemed inherent to the function of the judiciary. Number 78, Hamilton rests on judicial review, stating, limitations of this kind can be preserved and practiced in other ways than through the medium of courts of justice. Whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all reservations of particular rights would amount to nothing. The framers envisioned the judicial branch to have the least effect on the functioning of the government, approaching the establishment of the branch almost as an afterthought. The Constitution contains very little detail on what and how the judicial branch was intended to function. In Federal 78, Hamilton continued, it proves incontestably that the judiciary is beyond comparison the weakness of the three forms of power.
During the time shortly after the Constitution was ratified, the court held almost no bearing on our government. John Marshall set the precedent for the court expanding its own power in Marbury v. Madison, which established judicial review. Even though the court had the power of judicial review, it was not often utilized. Dred Scott v. Sanford was one of the first times that his decision in the Supreme Court had a significant impact on the people, often being considered to have contributed to the start of the Civil War. The ratification of the 14th Amendment after the Civil War established the framework for much of how the court makes decisions today. Prior to the 14th Amendment, the Bill of Rights was almost never cited, while it is now seen as one of the most important documents the people hold. Plessy v. Ferguson, Lochner v. New York, and Abrams v. U.S. were all landmark cases that helped create the more active reputation the court has today. Brown v. Board of Education, Roe v. Wade, and District of Columbia v. Heller are examples of the court stepping directly into the lives of American people, continuing the trend of expanding its effect on the functioning of our government. Each of these cases not only protected rights, but expanded them beyond precedent. These cases contributed to expanding the court's power to at least equal to the other branch of the government, which has continued into the present day, where we see justice nominations and Supreme Court decisions as some of the most important developments in our democracy.
There are four common methods Supreme Court justices use to interpret the Constitution: textualism, original intent, fundamental principles, and modernism. Each of these methods has its advantages and drawbacks. Modernism allows for the most freedom of interpretation, textualism the least, with the others falling in the middle. Examples of textualism are seen in Justice Scalia's cases, specifically District of Columbia v. Heller. In this case, Scalia used his interpretation of the plain meaning of the Second Amendment in his majority opinion. Justice Warren in Brown v. Board of Education employed the original intent strategy in conjunction with the text of the 14th Amendment to build an argument. Justice Blackmun's opinion in Roe v. Wade is an example of modernism, a constitutional interpretation method often associated with activist courts. The decision in Calder v. Bull utilized fundamental principles. One of the most significant ways that the Supreme Court uses its interpretive power to promote both the common good and individual liberty is by providing checks on the legislative and executive branches of government. This conflict between the branches came to a head during the Civil War and ex parte merryment. This back and forth between the executive and the judiciary is still seen today. Trump v. International Refugee Assistance Project challenged Executive Order number 13780, which suspended the entry of nationals from 6 designated countries. The court never actually heard this case because Trump's administration altered the executive order twice before its scheduled hearing. You could argue that these changes could be credited to the pressure placed upon the administration by the court. While the order was not explicitly contradicted by the court, it still provided an important check on the executive. It can be seen in this case that the Supreme Court holds what could be termed indirect judicial review, that the court shapes the behavior of the executive and legislator without having to explicitly comment on their actions. We're ready for your questions.
Very good. Would you like to begin?
Okay, sure. All right, so you've given some examples of maybe some implied limits that were placed on the executive by the court, but what are some limits that have been actually placed on the power of the court by the other branches?
I think the first thing that springs to my mind is their limit of jurisdiction. That they can only comment on those cases that work their way from the courts or when they utilize original jurisdiction. But that limit on jurisdiction really limits what the court can comment on.
And what do you think about the court's power of judicial review?
The court's power of judicial review is its founding, most important power. Without judicial review, the court wouldn't be able, it would basically be a figurehead, not a real branch of government, and that power of judicial review really gives it the power to shape our government and our society through commenting on actions of the legislature or the executive branch.
And the landmark Supreme Court case, Marbury v. Madison, is the one that set forth and established judicial review.
In Brown versus Board of Education, the Supreme Court overruled its prior decision in Plessy v. Ferguson. How could the court just overrule a prior decision when in both cases it was interpreting the same Constitution?
I think that idea of precedent being really important to shaping the court's decisions helps build consistency within the court, but also building off the principles of the Ninth Amendment and that freedom to interpret the Constitution and apply it however the people deem necessary. I think they took those principles and used that in reviewing their decision in Plessy.
All right, do you think term limits should be imposed on the justices? Why or why not?
I think that term limits enforce a certain responsibility on the justices. If they were being elected and only had a few certain views, they might take it less seriously, for lack of a better word.
I believe that with specifically state legislators, they have certain things that they have to keep up with our society, and in order to please, I guess you could say, constituents or people who are donating to them and things like that, they often go in other ways that they wouldn't if they were appointed a life term, and just so that they will be elected again.
Yeah, I would say that term limits would be contradictory to how the court functions. I think that life terms keep the justices from becoming politicized and influenced by lobbyists or financial interest, and so that they have that freedom to really impose those ideas and their study of the Constitution and law and make decisions about having to be accountable to a political party or the constituents.
Following up on this question about term limits and even this other consideration about politicizing the justices, it's clear that there's a common practice that sometimes a justice will wait to retire, though they may have a medical issue or personal things they'd like to attend to, because they're concerned about the current executive branch and their appointment. What do you think about a justice's interest in staying on the bench past a time that is probably best for them?
I think it can be, that's a tough question, because as justices get older and older, they gain experience, but sometimes their health or other considerations start to affect how they can perform their role in the court. But I think that those life terms and the limits imposed on justices in good behavior, it's really up to the justice to make that decision and rely on their experience to influence their thinking.
I think that also depends on, it's very situational, and you could go case by case with that sort of thing, because one health concern could be very different than another, so it could really differ depending on the justice.
In recent years, the choosing of Supreme Court justices has become highly political. Do you think that's a good idea?
I don't think so. I think that justice nominations are one of those things. Why they're nominated by the executive and confirmed by the legislative branch is because most people, normal people, don't have the level of expertise to make those decisions about who should be representing us on the court. And so I don't think it is really relevant, should be relevant to the political party or who's in power at that time, or really who's qualified for the job.
Okay. Which method of constitutional approach, textualism, originalism, which ones do you think are best and why?
I think it's important to have many different interpretations of the Constitution, so that you could keep checks on the other different types of interpretation, because it's important to let the Constitution evolve with our society, but we also know that our forefathers had certain ideas in mind, and
go ahead and finish.
And they knew what was best for our country.
Please give it up for our panelists. Okay, at this time we'll give you a little bit of feedback.
I was pleased to see your mention and discussion of Federalist 78 in your opening statement. That's an important document that deals with the concept of Plessy v. Ferguson, and your discussion of the how the court has expanded its power over the years was very good. And I would, you might have mentioned the role of selective incorporation, which is a doctrine that the Supreme Court has used in order to incorporate most of the Bill of Rights into and apply them to the states. So that's consistent with what you were saying, so that would have been good. I like your examples of Justices Scalia and Warren and Berger to talk about the three different kinds of interpretation. When I asked you about the differences between Plessy versus Brown, you said that consistency was important, but this was an example of the Supreme Court changing its views, and so it would be good to explain why the Supreme Court changed its view. One of the things that people have mentioned is that when the Supreme Court decided Brown versus the Board of Education, there were a lot of social science studies that were brought to the court's attention and that it relied on in order to reach a different result. Your discussion of age limits, I think, was good. One thing you might have mentioned was that a lot of the state courts, including ours, have mandatory retirement ages for judges, as opposed to the federal judges who can serve for life. There's no age limit for them to retire. But overall, I think Pledge did a nice job in answering all aspects of the question.
All right, yeah, your opening statement, what I really loved about it is you really did not look at things in a vacuum. You really looked at the context of it and figured out, after the 14th Amendment, then the Bill of Rights started getting a lot of play, or the effect of what happened in the Civil War. And then because of the expansive role of the Supreme Court, nominations have become ever important. I mean, who cared about it before if they were a weaker branch, right? So I really liked how you saw the context of it and how history kind of plays off on it, and the different roles of government play off on it. And even to current day, suggesting the implied pressure of a case going to court might have influenced the amendment of the travel ban. So I thought that was really, really great in your opening statement. And yeah, in your questions, nice answering the questions you were thinking about it. I think you may want to draw on more examples to support your answers to your questions, because you've been studying up on all these examples, and you might be able to plug those in a little bit more, so I just flesh them out a little more, but I thought you did a really nice job.
I concur with my colleague. One of the things I really appreciated was that you did talk about the travel ban and Trump versus the International Assistance Project. I also wanted to talk about this question that I posed. I think I was trying to kind of underscore that these justices are human beings, right? They do have thoughts and opinions and lives, but I thought you guys were very nimble, and now you answered the question and talked about how it was situational. Overall, I thought you guys did very well. The last thing I'll tell you is that I think you should trust your instinct. If you have an opinion about something, because there are a couple times I kind of saw a twitch, like maybe you wanted to say something, but you didn't articulate it. And so I just wanted to tell you to trust that voice and tell us how you're thinking about the issue. With that, please give them another round of applause. Great job. Thank you.
Nice job.
Thank you.
Thank you.
Good job. Thank you.
And then we're supposed to be back in the auditorium, but those of you that are staying for the award ceremony.
I'm Jackie Johnson, the state coordinator for the We the People program. And we're going to begin, and I don't think you'll mind, we're going to begin with a moment of silence because Platte Canyon High School in the 2nd Congressional District experienced a terrible thing this past week. And they lost an important member of their We the People team who was first missing, and then they feared the worst, that the young woman, they were not going to see her again. And she did in fact die in a fire, as I understand it, in her home. And the teacher, Hugh Miller, sent me an email and said, Jackie, I don't think we're going to make the state finals. Would you please fill our spot with someone else, another team? And that's the one consolation we feel, is that some other team will get a chance to experience the state finals. And I'll tell you who that team was in just a minute. But if you wouldn't mind, we're going to give Maggie Long from Platte Canyon High School just a moment of silence, please. Here's what he wrote to me in an email. It's been a very tough week. Maggie was an amazing student, classmate, and friend to all. She was involved in almost every aspect of the school, from all musicals and plays, the softball team, student council, and Key Club. She practically ran the school and had to be reminded to slow down sometimes. She was always positive and made everyone's day a little brighter. She will be dearly missed. Thanks for having her in your thoughts, and good luck to you all today. And I'm going to ask Victoria Bull from Northland High School to come up, and many of the students, and I think all of the judges, had an opportunity to sign a certificate that we framed. And Victoria, if you wouldn't mind giving it to Hugh to share with his class this week. Thank you. Thank you. Let me now recognize all of the fabulous teachers that have been a part of the 2017 state finals. And then Justice Gabriel from the Colorado Supreme Court, who is also a judge today, is going to come up and give a few words. But if you don't mind, Justice Gabriel, let me introduce you to all the teachers again. East High School, District 1, Mark Talhofer. Steve McNichols from District 4, Silver Creek High School. You know, I don't have my notes in front of me, and I shouldn't even need them. Let's see. District 6, Jeff Ryman, Grandview High School. District 7, Jefferson County Open School, Roberta Page. And another District 7 school, Northland High School. From the mountains, Ridgeway High School, District 3. Justice Gabriel.
Thank you all very much. I promise I'll be brief because I know you don't want to hear me talk. There are other more important things you want to hear about. I've heard a lot of people stop me in the hall and thank me for being here today. Let me tell you, I need to thank you. It was an incredible honor and privilege to watch all of you. And I said to a number of the teams I got a chance to see, and I was not being facetious at all, I saw some folks who answered questions and knew the law better than some lawyers I see, and I see a lot of lawyers. You should be very, very proud of yourselves. And the performance that I saw from all of you, every one of you, really suggests that we are in a good place. We hear a lot of negatives. We hear criticism of young people. But you know, I wish more people could come watch what I saw today. And I think they would leave the same way I leave, feeling very good about our future. You know, the sad thing is, in a couple minutes, somebody gets to be called a winner, and other people don't win first place. But know that every one of you is a winner, and nobody should leave here disappointed. I want to also thank and congratulate the teachers, all the teachers we just heard about. And a special thanks to all the many people sitting here in the audience, parents, friends, families, who came out to support you. Could you please give your teachers and all the folks who support you around the world? So I'll just leave you with this, and it's a request. For all of, particularly the young people, the young men and women who participated today, the work that you put in was phenomenal. It showed every single one of you, the effort that showed. There is some criticism of our society that I think is valid, and that's that many of our people don't understand the importance of our civic involvement. People don't vote when they have the chance to vote. We vote to retain or not retain judges. We stand for retention. We're not, in the state court, we're not appointed for life. And when I was on the ballot, people would come up and say, I never vote, I leave that blank, or I vote no on all the judges all the time, but I voted for you. It is our civic responsibility to get involved, to learn, to be an educated voter. It is the thing that separates us out from dictatorships and tyrannical governments. It's what makes this country as great as it is, the chance to participate and to have a real say. So what I would ask you to do, whether any of you go on and become lawyers or do this kind of debate thing down the road, whatever you may do, never lose that. Never lose your interest in civics and in what makes our government work. And be a leader. Be a leader in that for yourself and be a leader in your community. Educate people on why they need to educate themselves and to vote responsibly. You will take a lot out of that. You always get as much out from teaching as from learning. And so be a teacher and carry on this, what I saw today, the spirit and the involvement and the incredible intelligence and creativity in solving problems. Always take that with you and lead. So again, my heartfelt congratulations to each and every one of you in this room. I was very, very proud to be here, and I hope I'll get invited back again. So thank you.
Thank you, Justice Gabriel. And that reminds me, weren't these judges fabulous today? You know, those that come back year after year always come up to me and say, Jackie, these guys were incredible this year. And I got a chance to see, I think, 3 different teams today, and I really enjoyed watching and being a part of it all. So again, congratulations on behalf of the state program. What we've done, what we tried last year for the first time, and we're going to do it again this year, is to give certificates signed by Michael Bennett for the high-scoring unit of your class. And that's what I'm going to award now. And if somebody from that unit would please come up and get some special certificates that say you were the high-scoring unit of your We the People team. So, let's see. District number 1, East High School, your high unit was Unit 5. High School, where are you? Your high unit, Unit 1. Come on up. Congressional District 4, Silver Creek High School, your high unit, also Unit 1. Congressional District 6, Grandview High School, your high unit, Unit 3. District 7, Jeffco Open, your high unit, Unit 1. Unit 1. Somebody said when we're reading lunch, how come so many Unit 1s? Because it's your high-scoring unit in your class, not the high-scoring unit, but the one of the whole group, but the highest unit given the people that are in your own class. So that's why there's so many Unit 1s. Okay, as I mentioned, Michael Bennett, his office sent some certificates to Washington, D.C., and they came back to me, and they've all been signed by our Senator Michael Bennett. And now I have the scores that you've all been waiting for. I'm going to ask a representative from each class, maybe one rep from each unit to come up and get these certificates signed by Michael Bennett. And then we also have some blue ribbons. And everybody gets a blue ribbon today because you all qualified to even be here. That's the first place to even be here. So it's not that everybody's getting an award, although you kind of are, but you should have gotten this award last month when you took first place at your district level event. So could I have, please, the people from Ridgeway come up, please? Congratulations. For those of you in the audience that saw the program and didn't see the word Ridgeway, you saw the word Georgia, which is the state that they chose to be identified with today. Could I have Rhode Island, Jefferson County Open School, come up, please? So now I'm down to third place. Silver Creek High School, would you come up, please? South Carolina. You know, before I go further, I do want to recognize Northland High School for coming and only having 4 days to prepare. 4 days to prepare. When this event happened in Bailey at Platte Canyon High School, I sent an email to all the other teachers from the metro area whose classes had prepared all 3 questions. And I said that Hugh really wants a team to take his place. And so immediately when that email went out, Victoria Bull and the Northland class decided that they would work very hard for, I guess, just 4 days and to prepare one of the remaining 2 questions. And so we're calling them a showcase or an exhibition team. And they were the people that filled out the schedule for us, making it the 6th class. So thanks again, Victoria, for doing that. So now I'm down. And your team was scored, like the other teams as well. Now I'm down to place 2 and place 1. And I always have to say this, that, you know, the minute I announce the 2nd place team, you're going to know who is the 1st place team. But since everybody's worked so hard, I want you to recognize our second place team and then wish our first place team all the luck in the world at the national finals in Washington, D.C. at the end of April. In second place for the Colorado State Finals, Grandview High School.